Hi, my name is Brian Lepak. I am co-chair of the Law Practice Management and Technology section of the Beverly Hills Bar Association. On behalf of the Beverly Hills Bar Association, we welcome you to the program called iPad Software for Litigation Matters. Before we begin, I have some housekeeping announcements. You will receive your MCLE certificate shortly after the program. Your certificate will also be stored in BHBA Plus, our members-only community. Please take a moment to complete the survey that is included with your certificate. This program will be available for a couple of days in BHBA On Demand, BHBA's newest member benefit presented by Lawyers Mutual Insurance Company. If you're interested in joining the Law Practice Management and Technology section, please let me know. You can email me. If you're interested in particular programs, you can also email me that. And with this, I turn the program over to Tony Storm. You were on mute, Tony.
You sound good, though.
First error. I mean, always plan for a mistake. So, and here I was trying to be careful, Brian, not to talk over you. So lesson one, plan for the mistakes, because we all know.
I thought that was deliberate so you could show that even in the middle of live presentations, you better be flexible.
Well
planned. Stuff always happens. But thank you for telling me I was on mute. Otherwise, I would have been waxing poetic for a long time. But what I was saying is, thank you all for coming. I mean, I think this is going to be a great presentation. You'll find that we're going to try to go even more in depth than using only iPads. Lit Software has a suite now for the Macintosh computer that is amazing. You'll love it. We have great co-presenters with us today, and I'd like to thank them both for being here. We have Ms. Tara Cheever, who is the co-founder and products manager of Lit Software, who also assisted in the design and the development of TrialPad and all the related Lit Suite software. Judge Lewis is perhaps one of the most tech-savvy judges I have appeared before. Amongst his many accolades, he was the supervising judge of the Family Law Department at the Los Angeles Superior Court. I'm sure many of you who are watching have appeared before him and know firsthand how tech-savvy he is. As time permits, we are going to address the appropriate questions at the end of the presentation. You'll find in starting, digital trials isn't really a one-size-fits-all approach. It depends on what you want to present. For example, if you're presenting digital documents versus video, that's going to be different. It also depends how your judge wants to see it. Judge Lewis will talk about things you want to do before the trial starts. Some judges you'll find really like digital presentations, really like the remote trial. Other judges don't. So you have to know what your judge wants before you even start your presentation, and it's a crucial start to your planning. So rather than mimic somebody else's style, I mean, we all see Roger Dodd and these great trial attorneys. In my opinion, that's fantastic, but we need to learn from them and develop our own style of presentation. Where do you keep your camera? You have to be comfortable. You have to be flexible, because as you just saw, things happen that you don't expect. Your mic is off. The bulb breaks on your projector. You don't have a long enough extension cord.
The power goes out.
it makes a huge difference. You need to invest in the right technology. You need to know, like I said, you need to know the judge. Need to know if you can, it's funny, when we were preparing, I said, some people can do this at the same time, some people can't. Can you operate the software and have your flow chart listening to the examination of your witness at the same time?
So I'd like to go ahead and just jump in here if I could for a second, Tony. So there's a lot of research now that tells us we think we're good at multitasking, but we actually aren't good at multitasking. This is brain science now, not rocket science. And so I like this. I used to take notes at trial using my keyboard, and then I realized I wasn't actually listening to the witness. I was writing my notes. And so you need to be thinking about, where do you want your brain power to go in figuring out the technology, which you should know well before you ever walk in a courtroom? Or do you want to take your notes by hand, or do you want to hire somebody to handle the technology piece? I think those are all important questions.
Well, building on that, Judge Lewis, it's even more important. Proficiency in the technology is now a competency issue at the state bar. If you look at Rule of Professional Conduct 1.1, it will tell you. So if you don't know what you're doing and there's something bad happens, you could be on the hook. So it's exceptionally important that you know how to handle this technology. Especially, I mean, you don't have to have a digital trial, but the people who are here want to learn how to do it. And like I said, you can use it on your computer with TrialPad or on an iPad. I know the subject matter says iPad, but there's more available than just using your iPad. There's all sorts of tools that we can combine and use together. And we want to show you what the difference is. The difference is whether you're having your trial remotely or whether you're being in person, you're going to use different tools. And a lot of that too depends on what what your judge is going to want to see. So there's advantages to being remote versus in person. We were just talking with Brian about his recent remote trials and the great experiences he had with them. I've had great experiences with remote trials. When I'm remote, I'm not using an iPad. I'm using my computer and I'm using TrialPad on my computer. So we'll talk about technology. We'll talk about pre-trial case management orders you're going to want to make. You definitely want to file your notice of remote appearance form. My practice is I file it at the beginning of the case, so it never gets forgotten. That's the Judicial Council Form RA-010 for those who aren't familiar with it. And there's a checkbox where you can check throughout the case. There's no harm in checking that checkbox, but if you don't check it, there's possible harm if you're planning on appearing remote and you didn't give notice of same. So, you can shortcut a lot of things in your trial, which Judge Lewis will maybe talk about if you stipulate to certain things before you communicate with your, communicate with your client and understand what technology you're going to be using and how it's going to be used. And maybe the most important thing is practice. You don't know what's going to come about during your trial. There's always something that happens that's unexpected.
I'm going to jump in on there really quickly too, Tony, because I can tell you from the technology perspective that we work really hard to make sure that our technology works really well. But what we can't control is from that, whether it's an iPad or a Mac, out. So if you're going to be in person, well, first of all, I think Judge will agree with me on this. No judge likes technology that doesn't work. If it doesn't work, it's useless. It's a waste of everybody's time.
If you're in front of Judge Cranky or in front of Judge Luddite and you have technology problems, you have another set of problems, which is you are losing your audience. And that is something we don't want to forget. You do not want to lose your audience or have your inability to manage your technology have the judge thinking that your incompetence with the keyboard translates into your not maybe making the best of arguments, and the idea that you aren't hurting your reputation with the judge because you're no good at the technology. You just need to be aware of that. And if you'll permit, I'm going to use an example. In 72, I started working 1972, not 1872. In 1972, I started working with personal computers, and I had a job. I was at UCLA, and I was also had a full-time job. And my job was to load a personal computer with switches and loading the program with a teletype. When I first had the job, I was slow. I was no good at it. I never should be in a courtroom knowing what I knew when I first started that job. But by the time I had figured out the technology and had taught myself, trial and error, by the way, is the only real way you learn software, my experience. You got to keep doing it, keep doing it, keep doing it, keep doing it. By the time when I first started the job, it took forever to load that computer. Well, then I figured out how to do it. And what should have been an 8-hour shift really turned into a 2-hour shift because I knew how to use the technology. So I got paid for 8 and worked for 2. Now, before that, I probably was getting close to getting fired because I was no good at the technology side. So you've got to just say, and maybe you need to enlist a 5-year-old to help you with the technology. Don't want to get anybody too much older than 10 because then they're no good at it anymore anyway. But you've got to practice, 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 practice. And as simple of a thing as that is to say, your practice can't be happening in the courtroom. It has to happen beforehand.
Yeah,
Bill-
and to
Bill-
continue that point, I'm sorry, Tony, go ahead.
No, I was just going to quickly say, building on that, there are some people who are very practiced and can handle the technology themselves. For example, with TrialPad, you'll find out you're on direct. You can do a call out. We'll show you how to do that. And you can ask a question and you can pinpoint things and you can highlight that. And that might be something that the attorney handling the questioning, taking the testimony, can do. Although there's other things you might want a second chair to handle so you can focus and take notes while the witness is speaking. Tara, I'm sorry, go ahead.
No, that's okay. I wanted to say as well, so that that practice should start, obviously learning the software, whatever software you're choosing to use. The second part of that is the physical practice portion. So if you're going to be in a Zoom deposition, for example, get on a Zoom with, your paralegal, with somebody else in your firm, practice that way, connect the exact way you would. The same thing with your client. Get your client on that Zoom so that they understand. And I've seen so many Zoom depositions where the client, for some reason, joins on a phone. That's a terrible idea. They're not going to be able to see a document. If it's being recorded, it's never going to make your client look good, just because it's going to move around. So there's things like that. And equally, courtroom, get into that actual physical same courtroom you're going to be the Friday before the Monday you're supposed to be there. Plug in, make sure everything works. If you're bringing your own equipment, bring that equipment. And I say this so many times, and I mean it every single time. And the people that take that advice always succeed. That's just how it is, because there's the level of preparation there. And like I said, this could be something where you get into the courtroom on Monday and you realize that the outlet you were depending on, for some reason, that outlet doesn't have power to it, and you just presumed it would. I've walked into courtrooms here in Miami-Dade County where Lit Software is based, and that exact same thing has happened. And we had to have an extra long extension cord and literally run it into the hall. Our courthouse is very old. But that, there we go. Those sorts of things do happen. So just to have that out there, obviously we work hard to make sure our software is stable, but it's really beyond us. It comes into not just your practice, but also getting a real feel for the physicality of whatever courtroom you're going to be in. And if you're going to be out of town, you can hopefully have, local counsel go in or something like that ahead of time, or, arrive that Friday and plug in.
Well, there's an element I want to talk about courtrooms for a second that I don't think all of us are aware of. So, most courthouses have jails in them. And the more steel there is in the building, the less Wi-Fi there is in the building. And so not every court has a Wi-Fi repeater located right in that courtroom. So if you're going to be relying on the internet or a hotspot and your court doesn't have Wi-Fi access for you, or frankly, the Wi-Fi access that is available for the public is inferior. And that's what my experience has been, is that most parties find that court Wi-Fi isn't as high tech as it should be. You need to have a plan for that. Do you need the internet? For instance, you should have all the documents on your desktop or in a folder that's on the machine, not that you need to go to ShareFile to go get it or Dropbox to go get it. Because what if you cannot access the internet? And candidly, many courthouses, because they have bars, literally not for drinking or appearing, but for putting you behind them, that can really erode the quality of the Wi-Fi. So you need to have that figured out as well. Just because it works well at home or in the office doesn't mean it's going to work well in a government building, quite frankly.
That's a great point. And in your particular location, I was speaking with an attorney about 2 weeks ago who was in Los Angeles County, and she was mentioning that the public Wi-Fi kicks you off every 30 minutes. So if you're depending on Wi-Fi, which you shouldn't be, and our apps do not depend on Wi-Fi. If you are depending on Wi-Fi, your witness examination is over 30 minutes, which it's almost always going to be. You're out of luck. So it's a great point. Not only is the Wi-Fi not what you maybe have the expectation of, but you'll be kicked off after half an hour in a lot of locations.
Another reason not to depend on the Wi-Fi that people are commonly overlook are the text messages and emails that you will get in, and dings, and when your daughter or son texts you from school in the middle of your trial, it's very distracting. It's not something you want on the, if you're presenting a video, not something you want to pop up on the video. So in my practice, I clear my screen. I don't want anybody to see anything on my desktop. It's bare. I don't connect to Wi-Fi. I make sure everything is local on my machine there. I make sure that I talk to the JA before the trial, figure out when I can get in early to set up my equipment, which, quickly, obviously a projector, a screen, gaffer's tape, because when you have your extension cord, you don't want somebody tripping over the line, extra cables, an extra light bulb for your projector for that one time when you didn't anticipate your bulb to blow. I have heard a horror story about that, and it worked out, but plan for the unexpected with the equipment. And if anybody has questions on the technology, I don't want to dwell too much on it, but I'm happy to answer them at the end or after the program. But you need to get the documents to the judge. One question I had for Judge Lewis is impeachment evidence. When you have documents that you're not going to share, and maybe you're not on Wi-Fi, or maybe you do have access to Wi-Fi. I know how I've done it in my practice, and I can tell you, but I'd like to hear from you first.
Sure. Well, I've seen it done every possible way in the digital world. Of course, in the paper world, and we didn't say this yet, but I think we should say it right now. You've got to have a paper backup system just in case. You've got to have the exhibits there in paper just in case. You've got to have the demonstrative evidence available in chart or whatever other methodology as your backup, because your technology fails and you say, well, Your Honor, I just need 2 hours to get my tech guy down here or tech woman down here so she can fix it or he can fix it. Counsel, let's move on. So when it comes to impeachment exhibits specifically, know your judge. I know that every time you go to a CLE program, judges always say know your judge, but there's a reason why you keep hearing that over and over again. Because what I might like and what I think is cool may not be what the judge you're going to try the case in front of thinks is cool. So what I like is, if you're doing it digitally and it's an impeachment exhibit, I like you to not publish it. You've got to let the other lawyer look at the exhibit before you're going to show it to the witness. They have the right to see what that exhibit is. This is not trial by Kafka. Well, we have exhibits and witnesses against you, but we're not going to tell you what they are. So you've got to have a plan to share it with the other side. And how are you going to do that? Are you going to do it by email? Are you going to give them a flash drive? Are you going to do it by email? Does the email work in the courthouse? You've got to have a plan for how you're going to do that. And that's a conversation you should be having with your judge before the trial starts, not in the middle of the trial. So have the technology conversation early with your judge. That to me is probably the best choice. I like keeping all the exhibits in folders in Dropbox, the ones that are offered, the ones that are admitted, the ones that are marked. And if you need to put your impeachment documents in a separate folder so that they can migrate over, all for the good. But you've got to have that plan for how you're going to handle that. Because, and also, let's face it, the impeachment testimony is presented like this. In my hand, I have the letter. That's one way. Well, Your Honor, digitally, I have the letter. I'm having a little trouble with the internet right now because I didn't download it on my desktop. Oh, I can't find it. Can we take a recess? See, I think that the power of the impeachment, just all the air went out of that balloon because your technology was not working properly.
So you can't, or at least in my practice, I don't depend on the other side being proficient in the technology for the impeachment evidence. So what I've done in the past, and it requires somebody to be very detailed and keep track of things, is I password protect each PDF or whatever file type it is in a folder. I provide it to the other side in advance. They can't get into it. They can't see it. It doesn't require Wi-Fi, but when I'm ready to present it, I can address it. You know, I'd like to present, you know, counsel with, excuse me, I'm slipping over my words, but, you know, exhibit 11, impeachment exhibit 11, opposing counsel can see it by entering the password 1234. I mean, obviously that wouldn't be the password, but it requires you to be organized and for you to have your own internal documentation of which exhibit goes to which password, because if you mix that up, you're in deep. So I tend to be very type A and have everything detailed. I've never had a problem, but that alleviates the issue for me of them being able to see the impeachment exhibits that I don't want them to see beforehand, but still having exchanged them. And that password is universal. It could be used for the judge. It could be used for the other side. It's simple. I know Judge Lewis and I discussed having a joint share file for a trial, which may work too if you have the Wi-Fi access.
Be careful about those joint share files though, because I have had this come up in one of my trials. One of the experts was managing the share file, and the expert was looking at the log to see when the other side was accessing documents and what they were accessing. So if you've got a joint share file, you want to do is you want to go in there and download all of those documents to a separate share file that only you have access to. Because whoever is the administrator is going to be able to know when you logged on, what time you logged on, what you looked at. So just go in there if it's a share file and download all of it to your own repository so that no one is knowing how, you know, essentially that's work product. What you've been looking at and when you've been looking at it is a work product issue, and you want to try to be sure that you're protecting that work product issue.
So we've talked a lot about the background. I want to make sure we get into a bit of a deep dive and give Tara the opportunity to share her screen, and so we can actually look at TrialPad, look at it on the Mac, look at it on the iPad, see how it's different from using, hey, I just use Adobe Acrobat. What do I need TrialPad for? I can just, you know, point with my mouse on this. What else can I do and why? So I'm going to hand the virtual mic over to Tara and share screen and let you show us.
Sure. So there's a couple of things I want to talk about too as I'm going to share my screen. What I'm doing now in Zoom is when I tap the share button, I have the option to share just a window, right? So I could choose to share my TrialPad share screen, which I'm going to do, or I could choose to share my desktop, which obviously if I have icons or, you know, picture in the background, I'm going to end up sharing that too. So the first thing I wanted to do is to mention that. But secondly, because we're in Zoom, we have that option. Other remote platforms don't have that option. Often, other remote platforms force you to share a desktop. You know, so if you have one or two monitors, you're going to choose a monitor. And so thinking about, and I know Tony, you mentioned this before, thinking about what you're sharing is important. And if you've got, you know, the typical background with all the folders all over your desktop or a photo on there, that's not the screen that you want to be able to share. So with TrialPad, which I've just opened up, it allows you to really control what you're sharing. And so what I'm just going to do quickly is to give you an idea of what it will look like to the fact finder, whether that's a judge and jury in a courtroom or yourselves today on Zoom, or maybe a deponent. And so I turned output to off, and you should be able to see that my screen sharing stopped. If I turn my output to on, I'm now able to have that screen already ready to go. And you see it has that little TrialPad in the background, and that's what you were viewing. That lets me know that I'm ready to present a document. And then on my other screen that I'm looking at, I've got my document showing, and I'm just going to tap present in order to show the document. Then I've got a number of things I can do. Now, I'm on my Mac, so I'm able to do a call out using my mouse. If I'm in a courtroom, this is something I would do with my finger, or if you prefer, you could use a stylus or an Apple Pencil. And then you can do, a highlight of something important. If this, I think that's a sulfate, is important to my case, and move my call out around. And I bring this in just to contrast with what you probably have all seen in deposition, where a background is being shared and where maybe Adobe gets brought up. And there's just a lot of distractions where, especially in deposition, or especially if you're interviewing or talking to a witness, you really want them to focus on only what you want them to focus on. So with that, I'm going to turn off my share. And I did want to mention one other thing, but before I do that, I'm just going to go ahead and share my whole desktop so you could see what I was looking at when I brought that up. This is what you maybe wouldn't share, but I want you to all see it. And this is what the interface of TrialPad looks like. And so here's my mouse. You should be able to see. And one thing I'll mention, because Tony mentioned it earlier, and it's really important, is like the distractions, the pings, the texts that just inevitably emails, a notification comes in. And Apple has focus modes. I think other software has modes as well. But if you just go to the top here, this is on my Mac, I've got a focus mode. And I have one specifically created for court. On my iPad, on my phone, and on my Mac. You can do the same thing for deposition. And what you'll do is, when you create a focus mode, settings actually walks you through who you want to be able to reach you and who you don't. Whether you want sounds or not sounds. TrialPad builds that in. So if you're presenting and a text comes in or a notification comes in, you'll see it, but the output screen won't show it. So it does bring that in. But I did want to mention that's a very powerful little tool that's already built in, that once you've got that created, get a new phone, same thing. It's all part of your profile. And it's a really easy way to just walk into court, tap court, and then, remember to turn it back off when you leave, or else no one can reach you. But yeah, just thought I'd bring that up as well.
Building on that, Tara, my practice, just because I don't like to take chances, Apple is integrated, like you said. Everything, you have an Apple phone, you have an Apple computer, your cell phone rings. It rings, if you're on the same Wi-Fi network, your computer rings, your iPad rings, everything together.
Everything rings.
So I don't want—
You mean the part that I hate about Apple products, even though I love Apple products?
So I really don't want the distractions, because I don't even want them coming up on my screen. If there's, God forbid, an emergency, my wife will find me. Okay. I don't want 10,000 calls coming in, text messages, things that are distracting me during my trial. So I turn it off. Mm-hmm. I don't depend on it. And it's a commonly overlooked thing. I mean, can you imagine the distraction as when you're presenting evidence, and all of a sudden you have your do-do-do-do-do-do-do-do, or whatever sound your phone makes? Maybe that sound dates me a little bit, but but yeah. So I didn't want to interrupt, Tara, so please.
No, that's great. So I know the reason that we're all here now. We talked in the very beginning about what if it goes wrong, but the reason why we're here is how great it is when it goes right. Because what happens when it goes right is you have a very smooth presentation where you have all the information at your fingertips that you can bring up very quickly and easily. You look informed, you look prepared, you are prepared, and you start to become the truth in the room, which is what you want to be, especially in a trial. So I just want to walk through some of the quick ways we might bring documents in and present them in TrialPad on the Mac. And then I'm going to compare that with what you would see on the iPad. And then, Tony, I know you have experience with both of these. So do you, Judge. So please interrupt me if I'm missing something or if I'm skipping over something. This is our sample case. So what I had done when I brought this up was to just tap the call out tool, and I can choose a background if I want to. I didn't choose a background. And then whatever I highlight it with the mouse is what's going to be called out. So this is what I'm looking at.
I am going to interrupt.
Quick,
oh, we're both interrupting.
Go ahead, Tony.
The one thing I was going to interrupt with is it's important to note that what you may be seeing on your screen is not the same that's on the thing that's on the projector. You have evidence, you have notes, that you have exhibits that you're not going to want people to necessarily see as you're presenting. So knowing that, that there's a difference, and knowing how to set it in presentation mode versus, I forgot what it's called, Tara, but
yeah, it's presentation mode. That's exactly right. And
all right.
I'll give you a great example, because I'm just going to resize this window real quick, and I'll show you this output to on. This is what you want to show the jury. So when I'm pressing present here, TrialPad gives me a little green. It lets me know in case I've got this behind something else. I'm presenting, I'm live. Anything I do, if I do a highlight on here, it's going to get highlighted on the screen. I also have a freeze button that allows me to go find a different document. Maybe I want to zoom in full screen, and when I press present, it'll update on my presentation screen. So what I'm obviously sharing with all of you is not the way that you would share it. You'd really just be sharing what's on the right-hand side of my screen. And then of course you have the ability to just blank the screen when you're done using a document. Can always pop out to something different. And this is pretty tiny because I have it shrunk down, but we have little tools like same in the Mac as in the iPad, where double tapping makes you go full screen, double tapping again brings it back to size, and double tapping on the bottom will be full screen to the bottom. So there's little tools like that, as well as the highlight and the pen tool. Let me just go ahead and present this so you can kind of see what it will look like. So the pen tool allows me to maybe circle something. I have a nice little laser tool that just allows you to point something out very easily.
And Tara, why not Adobe Acrobat?
Sure.
Let's compare and contrast.
Let me do that. So I'm going to bring up that same Brotherwell document that we had earlier.
Or another PDF viewer if you don't have Acrobat. I mean,
no, this is Acrobat here. And so, what I'm going to have to do in this is to use my plus and minus buttons to zoom in and out. And then I've got some tools like highlighting, but you don't have the call out. The highlight, to be honest, it's not fantastic. It allows you to highlight lines of text. It doesn't allow you to, for example, highlight boxes or multiple, paragraphs at the same time. So it does have its limitations. And then while, more
than that, you're actually manipulating the document. You might want to have a clean document. So in TrialPad, you can do the call outs, but you're not necessarily saving the exhibit with your call outs and your highlights. But with Adobe Acrobat, you're doing it on the file.
Yeah, that's a great point. That's a great point.
Well,
and in
I'd like to just chime in here real quick. We have kind of assumed that these exhibits are now in evidence. Don't forget to lay a foundation and then move it into evidence before you start highlighting and publishing it. Publishing the exhibit is a word of art. It's a phrase of art, if you will. It means you're reading from it. We don't read from exhibits that are not in evidence. And remember, just because an exhibit is in evidence doesn't mean you can't read from it. The favorite amongst many less experienced lawyers is to say the document speaks for itself. That's true, counsel, but the document can also talk, and we can read from it. But you can't do, in my opinion, you can use the call out and the highlight to help you in the authentication process, but it is not a substitute for authentication and it being in evidence before you are publishing what the document actually says, unless it's part of the authentication process. Don't forget that, because if it's not in evidence, you shouldn't be reading from it unless it's part of the foundational elements.
And one thing while we're talking about foundational elements and just trial practice that we didn't cover that I think is important is to, even if you're appearing remotely, make sure your witnesses are excluded. Otherwise, they're going to be watching everything. The JA may be able to set up breakout rooms for them or call them in at a certain time. If there's time remaining, we can talk about certain pretrial case management orders you're going to want. But let's get back to the actual software. I just wanted to make sure that we didn't gloss over that point.
And I think Judge's point is well taken. One of the tools that we have in TrialPad for that reason as well is the ability to mark something admitted, so that it's really quick. You just kind of like press on the face of the document and you can mark it admitted. It gives a little green tag and it allows you to sort by documents that are admitted. Now, this is nice because while you always want to make sure that a document is in evidence and admitted into evidence before you present it, you also don't want to be on day 5 of trial trying to remember whether this document has already been shown and been admitted. It's all about being efficient and not wasting anyone's time. You don't want the eye roll from opposing counsel going, yes, we admitted that day 3. You don't want to have that come up. So have a very quick and easy way, again, whether it's TrialPad or something else, that you're easily able to identify before you bring something up, whether or not you've got to move it into evidence, or if it's already been moved into evidence. It's easy to say, I'd like to present what was previously marked as Exhibit 2. You know it was previously marked. You know it was already done because you've got this admitted tag there. So I did want to point that little tool out as well. Importing into TrialPad is a very easy thing to do, especially on a Mac. You can do it on an iPad as well. But really, I think the way that most people bring things in is just dragging and dropping in. So what I'd like to do just quickly is to quit and restart it so that we can just see the process of how I might create a case and start bringing some things in. So I've just clicked on the case and now it's going to ask me to create a new document. And here, if you're familiar with Mac at all, this is a Finder window and it's just asking me where I want to save this. And I've got a little folder called TrialPad Cases where I'm going to keep my case. And then create a new file and call it BHBA because I'm very creative. And now I've got the ability to import documents. And if I do this or import a folder, this will navigate out to anywhere in my case or in my computer, or I can easily pull up a bunch of exhibits. I'm just going to grab a few of these that I've got from before and just drag in exhibits. And so these are all now here and ready to go and ready to present. And then there's organization tools in terms of being able to folder, rename things, move things around, and then even pre-annotate and save them. So we try to make TrialPad very, very easily done. But that said, I do want to talk a little bit about the difference of presenting in person versus presenting remotely. I think, Tony, you mentioned that when you're presenting remotely, you're always on your Mac. I completely agree that that's the easier way to do it. If you're presenting in courtroom, I recommend the other way around, presenting with an iPad. And the reason being, yeah.
One thing to note, most of the people I think who are probably watching, I'm making a presumption they're making their appearances in LA Superior Court. They don't use Zoom if they're being remote. They use Microsoft Teams for the remote appearances. So go ahead. I didn't mean to interrupt.
And that's a great point. And that's actually a part of the reason why I think it's much better to present from TrialPad for Mac if you can in a remote, because then you've got a desktop and you've got a window that you can share. And Teams allows you to share just that window or your desktop. If you're doing a Zoom presentation, it's very, very easy with iPad. But if you're going to use the iPad and you're not using a Mac and you're going to present via Teams, you're going to need a third-party screen mirroring tool. It just starts to get, unless you're pretty tech savvy, it just starts to get a little bit hairy. And if you have the capability of just using a Mac, I would do that instead. In a courtroom, however, it's great to be able to stand up and sit down with something that's smaller than a legal pad and is comfortable. And you have the option, obviously, of second chair presenting for you or presenting for yourself. And so what I think I'd like to do, if it's all right, is to stop this share and just show you the iPad interface. And we can kind of talk about the differences of what you recommend for an in-courtroom versus a remote type of presentation. So since I'm on Zoom, what I'm going to do is share my iPad screen via AirPlay. Okay.
And while you're doing that, you're sharing, I just want to note, to the extent possible, it's good practice to start preparing for trial at the beginning of the case. Start gathering your exhibits as the discovery comes in and looking at them, because it's a lot less work. And somebody asked a question regarding this, but it's a lot less work to set up TrialPad as you go than to do it in one solid block. So when you know that an exhibit's going to be important, nothing precludes you from having your case set up in TrialPad 6 months before your trial is scheduled.
Yeah, and also because it's in that mobile format, being able to go to a meeting and just bring it up, whether or not you're going to ever present it, just having it with you instead of having a banker's box, it's very helpful. You know, a client calls, you've got your iPad with you. It's easy to just open up and reference a document or a video or an email somebody sent, something like that. So now I'm using TrialPad for iPad to connect to Zoom, and I'm just going to present that same document. And what I'm doing now is I'm going to use my finger to do that call out. Same thing that we did before, and my finger to do the highlight and sort of move this around. So if you're on Zoom, it looks the same, but if I was on Teams, it would be just a little bit more complex. So just going to turn on screen mirroring here so that way you can see what my iPad screen looks like. And so here's TrialPad, and I've got a little trackpad so that you can kind of see where my finger is touching the screen. And this is the case. Looks very similar, but here again, I'm using my finger. So it starts to be, and I'm mobile. I can walk around. I can be connected to an Apple TV. You do not need Wi-Fi for an Apple TV. You don't want to use Wi-Fi. Everything here is being stored on my iPad. And what I'm able to do is bring up the document by just selecting it. I can navigate through my document like a book. Just move the next page, previous page. Can make bookmarks. If anything's been done in Adobe and already bookmarked, those bookmarks are going to be are going to be brought in as well. And then I've got my annotation tools at the top, just like you saw on the Mac, where I can choose to call something out and maybe make a border.
Tara, how do you organize your documents on this? I know we're talking about presentation, but if you're setting this up and getting ready for trial.
Yeah, it's a great question. I've seen people do it really two totally different ways, and it really depends on what you just said. Are you building your case as the case is progressing, or are you just bringing it in for the purpose of trial? You know, if you're just bringing it in for the purpose of trial, chances are you've been working with some kind of a file folder format before. And what I would do is to just basically zip that and bring it in. TrialPad knows how to uncompress zip files, and you're going to end up with those same subfolders that you can navigate through.
And bringing it in on the iPad, because are you plugging in physically when you do it, or are you doing it through a Dropbox or a share file link?
Yeah, any of those ways. TrialPad for iPad allows you to bring in a USB, and the way that you import into TrialPad, you can go into multitasking, for example. Up here, I can put it on the side, and I can choose a storage location, and then I can drag in from a storage location into my folders. Or if I go, go full screen again. If I go down here, I can choose to import documents, and this will, I can't import into the sample case. If I import documents or import folders of documents, this is going to navigate out to the USB or Dropbox or any of the any cloud storage app that is available for iPad. And you can see I've got a couple of them listed here: iCloud Drive, Dropbox, OneDrive, Box. Any of those can be used, and if I do plug in a USB, that will appear as well. So you know, if you're going to use like a cloud storage, just be aware of the size of what things you have there. You're sending them up to the cloud, and then you're going to have to pull them back down. The fastest way is to use a USB or AirDrop. If you've got, if you have a bunch of files on your Mac, you can easily AirDrop them in as well. So yeah, that's the way that you would be able to import. It's a very flexible import process. And you can also, for example, I could go into Mail and then find a PDF and open that PDF in TrialPad. Of course, my screen went blank because TrialPad presumes I'm going to present something.
While you're opening that up, I just wanted to make a comment about convention for naming. Frequently, we like to name things by date. And I would just really urge you to consider using year, month, day convention, not month, day, year. Because if you bridge more than 1 year, all of the 22-01s are all going to be 22-01. But if you go 01-0122, and then you have an 01-0123, it's going to put the 23 document right after the 22 document because you didn't use year first naming convention. The other thing I would just say about naming convention, don't make it so it needs to be a Goldilocks convention. It needs to be just right. The name has to be understandable to somebody who didn't create it, and it has to be short enough that it will be readable and not so lengthy that it becomes either adversarial or just incomprehensible. So really knowing how you're going to name things. But that one issue of using year first, I think, is a very common issue because frequently we are trying cases based on a timeline. I think it's just a logical way to do it, but we don't always logically name our exhibits, and you should have be developing a good protocol for how you name your exhibits and able to explain it to others, especially your judge.
Tara,
That said,
sorry,
go ahead. No, that said as well, think about the way that you're going to be giving documents over to the court. Is that where you were going, Tony?
That's exactly where I was going, saving and exporting.
Yeah. So if TrialPad allows you to do it by the name of the document or by the exhibit number. And I find that once you've got exhibit numbers in court, naming it by the exhibit number is the best way to do it, because you might call it the January 3rd memo, but that might be what you call it in your head because you've been in this case for 5 years. The jury's been in it for maybe a week or two. They're not calling it whatever you're thinking of it as. They're calling it whatever exhibit you've been naming it the entire time. So I do want to point out 2 quick things. One is that export. So if I just select everything in here, and I'm gonna add exhibit stickers to them, and I'm just doing this very quickly, so it's going to be kind of start with 1 and apply exhibit stickers. Now I've got exhibit stickers on everything. If I want to now say only send out my admitted exhibits, so here's my admitted stuff. I can select all those admitted exhibits, and I can export it by exhibit number. And what this will do is it'll allow me to export right to a thumb drive if I want to do that, or I can upload my documents, and I get a preview of what it's going to look like for the person that's going to have that file, right? So if I want to call it exhibit defense 40? Do I want to call it just exhibit 40? There's a lot of different ways to deal with it, but you get the preview here, and then you can export it by that name. And so I recommend doing that. But in addition, when you're presenting, at least in TrialPad, we have a document label. That is important because if I turn output to on and present a document, let me find a multi-page document here. So this is a 2-page document and exhibit 42. If I'm on page 2, my jury that's taking notes has no idea what exhibit I'm on unless they've been really paying attention. And if you're flipping back and forth between exhibits, day 5, 6 of trial, they need to be able to know what they are looking at. So having an exhibit label that says, that this is exhibit 42 and this is page 2 of exhibit 42 also lets them take that note if they want to, so that they can refer back to it when they are deliberating. They might go through their notes and see exhibit 42, page 2, 10 times in their notes and say, that seems like an important one to me. What was that? And look that back up. So, whether you're using TrialPad or you're being analog or you're using a different program, have the opportunity to make sure that even though you know what you're looking at because you've been in this case for a long time, that the jury also knows what they're looking at, because they're the ones that are going to be deciding at the end of the day. And if you're not in front of a jury and it's in front of a judge, it's also helpful. I know Your Honor always paid perfect attention every single time. But we've all seen judges that got a really important email and they're just checked out for this particular witness for whatever reason. Make sure that there's a record in the court, what the court reporter's typing and in what you're showing them of exactly what they're seeing.
On this issue, what I do and I'm sure Judge Lewis will agree, everything is Bates marked. Everything is Bates numbered. It makes it much, and not just in the top corner, I do it at the top and the bottom. Makes it much easier to find your document. So it's in my, and another big difference that I do when appearing remote versus in person is I try to mimic the courtroom when I'm remote as much as possible. Some of you may think this is asinine, I don't know, but you know, I have a standing desk and I like to make sure that I'm looking up at the bench. So I will, like I'm doing now, I think it's a psychological thing. I like the judge to feel like I'm looking up at them. So it does mimic the courtroom as much as possible. Minor, but it's just something I've done in my practice. On the contrary, though, you know, just so you know, it does make it harder to type because you are up higher.
I would just also add that, remember, some pages of an exhibit might be admissible, but other pages may not be. And so you need to be able to plan that you can tear an exhibit apart. Let's say you've got a 40-page exhibit and the court says only pages 2, 4, 6, 8, and 10 come into evidence. You're going to have to be prepared to make the changes to the exhibit or redact out what hasn't been admitted. And you need to be proficient in doing that. And that's something you probably are going to have to do on the fly. And you know, it's much easier when it's a paper exhibit, frankly. If there's 40 pages and only page 2, 4, 6, and 8, and 10 are going to go in, rip it apart, pull the pages, say, okay, here's exhibit D, or whatever letter or number it has. So technology is great, but technology isn't always better than the paper way of doing things when it comes to this kind of issue. Because going through a lengthy exhibit, which means you should be planning in advance what you know isn't going to come into evidence. Maybe you just need to have it redacted out so that that page has nothing on it but black, so to speak. It's blacked out, but you've got to have a plan for that.
Well, the JA is always going to want a paper copy.
Mm-hmm.
Oh, they're going to probably insist on a paper copy so they can scan it and put it into their digital library as well. But that goes to the issue of, does the judge use your thumb drive, or does the judge want you to email it to them, or how do they want to handle that? Different judges have different views.
Yeah,
So
absolutely. I've had a judge here in Miami-Dade County. Again, I know we're on the other side of the country, but there are some that say we only want paper, and others say, I don't want a piece of paper in my courtroom. You know, don't bring in your 20,000 pages of documents and stack up my tiny courtroom. Everything has to be done electronically. And when you do have an example like that, everyone knows how to use paper. There are people that know how to use paper really well because they've organized well and they're not wasting time getting what they need. It should be the exact same with electronic presentation. You have to know how to do it, or know how or know someone who can, because there will be judges, and more there are, who just don't want all that paper in the courtroom.
And Tara, it's really synonymous. If we keep your screen up, say you've only used paper your whole life, and you have a notebook that says photos and a notebook that says reports. Mm-hmm. It is the same. If you really analogize it to what you see in Dropbox, you have your same folder, not Dropbox, excuse me, in TrialPad, you have your same folders that you would be listing as you might have in your trial notebooks. So it's really, it's not so different. It's just a different device. We have 5 minutes, and I do want to circle back to the very beginning and to what we might want to do pre-trial, what we might want to be asking of our opposing counsel, what pre-trial case management orders might we want. So I'm going to ask Judge Lewis what he recommends doing before your trial starts. You want this trial to be efficient. You want your evidence to come in. I mean, we've discussed this, Judge Lewis. The rules of evidence are there to teach you how to get your evidence admitted, not to keep evidence out necessarily. But so, quoting you, I'm not taking credit for that at all. That's, you know, it's very eloquently put, but by you, not me. So what do you want to do pre-trial?
Well, maybe could we take the share screen down while we have this conversation?
Yeah, sure.
Okay, great. There we go. Well, of course, I think the first question is a self-inventory question. How competent are you to be the technology genius? You're going to have to devote the time to learn, just like I had to devote. Now, I was lucky, I was getting paid, but you are too. Now, whether you bill the client for all of your learning, I don't know that you should be doing that, but at least remember, you'll be more efficient in the long run if you take the time to learn the technology. So do it, because the fact is that for some of you who are much younger than me, the world will probably begin to migrate more and more to digital in the legal field, although we're pretty doggone slow to do so. Even the Supreme Court is still in the paper world, I think, the US Supreme Court, I think. So just be mindful of that. Be mindful that you have to be able to, in a kind way, professionally, explain to the other lawyer that, yeah, this is going to work better for both of us. For instance, I had a trial that we did where one of the lawyers had 6 iPads that all synced automatically for what exhibits were in evidence and not. But that had all been worked out in advance with opposing counsel. So I think that the more you can meet and confer, but here's the other thing. Remember, you want to get your judge involved in that conversation. You don't want you and opposing counsel are all high tech and super happy with high tech, and you have Judge Cranky or Judge Luddite who isn't technologically minded. So you've got all these great technology ideas, and he or she doesn't like the technology side of it. They like the paper side of it. So I think getting some pretrial orders. The other thing that will be interesting to see is what the legislature does. You know, there is a CCP section 367.8 that calls upon the legislature, it calls upon the Judicial Council to provide statistics about remote trials by July 1 of 2023. They're supposed to take reports, and by January 1, 2023, submit a report to the legislature about remote trials. So I'll be very interested to see if they make that date. My experience is that they probably won't. But nevertheless, I think you need to have that conversation with opposing counsel and with the judge. And I'm sorry I've said that twice.
No, and I mean, to the extent you can, stipulate to foundation and the admission of.
Yes, absolutely. Absolutely.
Last minute for some questions that have arisen that are for Tara. How can, and I'm just going to list them off quickly because we have a minute. How can we use this for depositions? Does TrialPad autosave? What about Doc Review Pad and Exhibit Pad?
Yeah, so Doc Review Pad, Exhibits Pad is a free app that anybody can download. Works very well with our software, but you do not have to have our software to use it. It's an electronic exhibits binder that's meant to be able to turn your iPad into, instead of handing paper binders over to, for example, an arbitrator or to a jury, and it allows you then also to have some video in. Apple has what's called guided access. It's a triple click and you put in a code, it locks the iPad in one particular app. And that's what Exhibits Pad will be able to do, so that you can send it back to a jury or put it on a witness at the witness table, because then they can be sanitized. In terms of saving, yes, TrialPad automatically saves admitted status and any exhibit stickers. And then you can choose to make any of the documents will stay clean. You can make them key docs, and those will also save any of the annotations that you make on. So you have an option for the annotations, whether you want that saved or not. Using TrialPad in deposition is exactly the way that you would use it in trial, really. It's just a matter of, how, if it's remote, how are you sharing it? And you're going to share that output window. In person, I've seen lots of people in deposition bring it into the court reporter's office if it's being held there, or into counsel's office, and you can hook right into a TV right in a boardroom that might be there in a law firm. Just as easily, you can bring in a little projector and screen. Most law firms have something that you'd be able to plug into and present And so, and I've also seen people bring, there's little small monitors that that are literally fold up now, and you can bring those in and present to those. So that's how you'd use it in deposition. Just the same way you'd hand a paper document over, you presenting that, you know, on the screen and everyone can see it. It's actually very nice when it's done like in a Zoom and it's recorded, because then you can have a separate feed for the document, and for trial purposes, you can knit those together if you want to do that and play that deposition back. Doc Review Pad and Transcript Pad and TrialPad are all part of Lit Suite. So if you download TrialPad, you automatically have access to the other software in the suite. So the way that most of our customers use Doc Review Pad is to have everything that they would need to reference in their case in Doc Review Pad, and then send select sets of that out for purposes of presentation. So if you have a hearing coming up, you might want to only send the documents into TrialPad that you're going to present when it has to do with that hearing. Same thing for deposition. And then when it comes to trial, you know, if you've got 20,000 documents, you're never going to show 20,000 documents at trial. It's just not going to happen. But you might want to be able to access them all. So you might have all 20,000 in Doc Review Pad, and a smaller subset of maybe 200, 300 documents that you're sure you're going to want to show at trial. And it's literally a 3-second, it's a press of a button and an open TrialPad. And then you can bring any other additional documents that you didn't think about from Doc Review Pad into TrialPad. So they all do work together. And I know today was mostly about using the iPad for presentation, which is why we stuck on TrialPad and talked about that. I think that answered all those questions.
You did. There's a final question. I'll see if I can answer it on my own quickly about jury selection. Last jury trial I had, because I'm a family law, we don't have jury trials. I wasn't always a family law attorney. Before then, I used Post-its, very old school when selecting, when picking jurors. Is there an application that you're aware of that people use for jury selection?
There was one that I'd seen a long time ago. To be honest, it was too slow. You have to be so lightning fast, and a lot of times just being able to write and use your own shorthand is the fastest thing to do. And I love the Post-its, because someone gets moved, you can easily throw it away and shuffle everybody over. Yeah.
And that's it. So I think we've answered all the questions. I'd like to thank both my co-presenters, Judge Lewis and Ms. Tara Cheever, for being here. If anybody has any other questions, you can email me directly. We didn't get into equipment as much as we could have, but we're out of time. You can email me. My email address is Tony, Tony, @ storm, STORM, Palyan, PALYAN.com. And I'm happy to answer whatever additional questions you might have that we may not have gotten to. So thank you, everybody, for attending. Thank you both for what was a really helping put together a very informative program, and we very much appreciate it.
Thank you.
Happy holidays, everybody.
Yes.